version of the accused and his explanations given outside of the scope of any legal proceeding against him, this could have been useful for establishing the truth. And these are the reasons for my decision for the admissibility of part of the reprint, that is to say 47 out of 62 such tapes. The reprint presented by the Attorney General is said to be a reprint of 62 tape recordings, divided naturally into 62 reprints, in brackets, separate parts, each of which carries on its face the number of the tape which it represents. 47 of these reprints of the tapes do not carry any corrections or remark in the handwriting of the accused, and furthermore they are corrected by a set of special set of references with additional remarks made by the accused, and which constitute part of Exhibit T1393 in brackets file 17 mentioned above, all of which is edited in the handwriting of the accused. It is my view that these corrections and notations and additions in his own handwriting link the accused very directly with the above-mentioned 47 reprints in such a way that these reprints are now become documents of the accused which may be submitted as evidence against him, and the accused has the duty of explaining them. In the very fact that the accused and Sassen maintained in Argentina a series of recorded conversations about the activities of the accused during the period of the Nazi Reich is not in dispute. The accused admitted this fact in his comments to the Life publication in brackets T4751, and even recalled in this connection, quote, eine maschinenschriftlich wiedergegebene Tonbandtranskription, that is to say, a reprint of a tape recording reproduced in typewritten form. Exhibit T48, page 7. The question which is to be discussed at this stage is whether or not the reprint which is now in the hands of the prosecution is prima facie a true reproduction of the statements made by the accused in these above-mentioned recorded conversations. Since, from the point of view of its entire contents and form, brackets as described above in a general form, this above-mentioned reprint presumes to be a verbatim transcript of a recorded dialogue between Sassen and the accused, with notations of the serial number of each one of these tapes. Then, when the accused added in his handwriting the above-mentioned corrections and remarks to the 47 above-mentioned reprints, he, without any doubt, saw that the object of his corrections and proofreading was not just any kind of document, but a document presuming to be a verbatim transcript of his recorded statements, his own recorded statements. Under these circumstances, it is clear prima facie that in presenting this document and in adding to these statements, which presume to be his own recorded statements, various remarks to the matter itself. In doing so, the accused made reference to the object of his proofreading remarks and his other notations, and he regarded this as a correct replica of his recorded statements, and through this conduct he verified and authenticated the veracity of the transcription, and he did this implicitly. Therefore, it is my view that the Attorney General, the distinguished Attorney General, is correct in saying that in applying to these 47 reprints the doctrine of, quote, adoption of statements, unquote, or to be more exact, a verification of statements by the accused, vide Phipson on Evidence, volume 9, page, edition 9, page 259. Documents which are or have been in the possession of a party will generally be admissible against him as original (circumstantial) evidence to show his knowledge of their contents, his connection with or complicity in the transactions to which they relate, or his state of mind with reference thereto. They will further be receivable against him as admissions (that is to say, exceptions to the hearsay rule) to prove the truth of their contents if he has in any way recognized, adopted, or acted upon them. Vide also Wigmore on Evidence, Volume 4, Section 1073, pages 90 to 92 and page 97. This doctrine cannot apply to the 15 reprints which include on their face which do not include on their face any notations or remarks in the handwriting of the accused, and about which there have been made no such remarks. For the authentication of these 15 reprints, the Distinguished Attorney General refers to the identity of the typewriters with the other material and about identity in style of the remarks of the accused in these reprints with the style he uses in his statements to the police (exhibits T37). It is my view that there is not a sufficient basis for the verification of these reprints, and in the absence of their authentication by the accused or by another witness, these should not be received as proof against the accused. Now, as for the 47 verified reprints, the 47 reprints verified prima facie by the proofreading remarks and other notations made by the accused, all of the remarks made by the distinguished defense counsel do not pertain to the admissibility of the documents, but to their evaluation alone. The claim with regard to lack of integrity, the absence prima facie of 5 additional reprints of tapes, and the absence of about 150 additional remarks made by the accused. This is not an argument against the admissibility of the existing material, but pertains only to its evaluation. The lack of ability on part of the Attorney General to present to court the reprints of all the conversations which were recorded between the accused and Sassen does not invalidate the reprints of those conversations which he is in a position to submit. The lack of his capacity to find all of the 200 remarks to the reprint of the recording made by the accused or which he intended to have made does not invalidate neither the reprint nor the 50 existing remarks in file 17. One should note that these remarks by the accused are in the nature of additional statements which do not generally invalidate the correction of the transcription of the recording. Whether the accused adds anything to the content of his recorded statements, or whether he detracts anything, makes any reservation, or even retracts anything in its entirety, his prior statements remain standing, and all of his additional remarks do not pertain to the admissibility of these statements, but only to their evaluation. The argument of falsification or misinterpretation of the recorded arguments by Sassen is prima facie in contrast with the conduct of the accused when he proofread the reprints of the 47 tapes and added various substantive remarks. Under such conditions, the burden of proof for this argument is on the accused. The argument of a written agreement with Sassen that he would not publish anything which would not be authorized and verified by the accused by his signature pertains prima facie only to the publication of these matters and does not invalidate the fact that they were stated. It is reasonable to assume that the accused wanted to reserve for himself the right of deciding about the extent of publication and a final formulation of his matters for publication, but for the purposes of a criminal proceeding, any word that he uttered To the extent that it does not pertain to these matters here, is admissible as evidence. The argument that the accused did not have a chance of proofreading the entire printed material pertains chiefly to those 15 reprints of the tapes in which there are no corrections or handwritten remarks by the accused, and which for one reason or another, and which for this reason were not accepted as authenticated. Whereas, with regard to the other 47 proofread reprints, which were prima facie proofread by the accused, there the applicable rule should be errors and omissions accepted, and the accused should be permitted to point in his testimony to any mistake or misrepresentation in the transcription and should be given the chance of correcting this. With regard to the request by the Attorney General to admit the reprint in question on the basis of the identification of the handwriting of the accused alone, and identification which was not disputed by the distinguished and learned the defense attorney, here the question arose whether the Attorney General should call upon Sassen as a prosecution witness, since his testimony, according to the argument by the distinguished defense counsel, is the best evidence to prove the veracity of what the statements of the accused, or whether the Attorney General may, as he argues, to leave it to the defense counsel to call Sassen or any other witness who was present during the original conversations as a defense witness if he so desires. The law in this respect I regard as clear. There is the alternative how to verify the choice of how to verify documents is left to the Attorney General. A verification through the identification of handwriting is not less admissible than any other kind of verification, and the Attorney General should not be forced to call any witness which is not convenient or suitable for him, or which he does not regard as reliable. Vida for this, Archibald, edition 34, section 1125. Admissions or confessions to person other than magistrates, if in writing, are proved as any other written instrument. R.V. Watkins, R.C. and F. 548, and Phipson, page 538. The handwriting and signature of unattested documents may be proved by calling 1. the writer, or 2. a witness who saw the document signed, or 3. a witness who has acquired a knowledge of the writing, or 4. by comparison, or 5. by experts, or 6. by the admission of the party against whom the document is tendered, whether such admissions are expressly made for the purposes of the trial, or are merely of an evidentiary nature. The above methods, being equally admissible and equally primary, may be resorted to indifferently, subject of course to observation, should weaker proof be tendered where stronger might have been adduced. View also 113, 2QB, 1892, Lucas versus Williams, Wright versus Cobb, 1 TLR 555. In this latter case, the prosecutor tried to prove the veracity of signatures on bills through identifying the handwriting of the signatories, but the court decided that she had to call as witnesses either the signatories themselves or a witness who saw them sign, since he was of the opinion that this was the best evidence, in contrast with the identification of the handwriting, which in his view was secondary evidence. In overthrowing this lower court verdict, Lord Coleridge said there, secondary evidence of handwriting is not secondary evidence. It is good prima facie evidence. The judge gave a ruling that the party himself, whose signature was in question, or someone who saw him write it, must be called. It can only be accounted for by the extraordinary influence of the learned counsel. It really is not arguable that a judge can compel parties to call such witnesses as he pleases, and in the order in which he pleases. This is in 11/52, Law Reports, Volume 12, 1905, 1921, and 28/59, Law Reports 13, 1205, 1209. These are not, in my view, references for or precedents for the argument that for proving the veracity of the statements of the accused in his recorded conversations with Sassen, it is necessary to call on Sassen or any other witness who was present during the conversations. These two above-mentioned judgments did not discuss a matter where the transcription of a recording was verified explicitly or implicitly by the accused himself. Paragraph 37, brackets 2 of the Criminal Procedure Ordinance, brackets judgment upon indictment, does not, in my view, apply to this case in question. This paragraph determines a certain form of proof with regard to a statement presented by the accused. The present accused was not in the nature of an accused at the time of his conversations with Sassen. Therefore, one cannot regard his recorded statements as, quote, a statement presented by an accused. From the context of the three subsidiary paragraphs of paragraph 37, brackets 1, quote, statement presented by an accused in the course of a preliminary investigation, which was written by an examining magistrate, and Title 2, not in the course of preliminary examination. Title 3, in front of an examining magistrate or in the course of a trial. It is evident that the paragraph deals with statements presented by an accused in various stages of his examination. The contents of paragraph 37, 2 points in the same direction, particularly in the second sentence, quote, if the statement is taken in writing, reduced to writing, and attested by the accused in another way, then this statement must be verified by the testimony of a person who was present at the time the statement was given, a person who heard the statement and saw the accused when he signed it and attested to it in another way. This heavy procedure is not frequent unless, as was pointed out by the learned Attorney General, in cases where testimony is taken by the police in accordance with paragraphs 2 or 3 of the Criminal Procedure Ordinance, in brackets testimony. One should not enter into the Procrustean bed of the provisions of paragraph 37.2, the variety of forms in which people formulate their statements in writing or viva voce in the course of their natural everyday life, and one should not assume that this was the intention of the legislator. Paragraph 37, brackets 2, provides other forms of proof for statements which were presented by an accused under certain circumstances, but it should not be interpreted as a general law which regulates and limits ways of proofs with regard to statements and announcements said or written by a person in the course of his everyday life before he became an accused. Interpreter's comment: the rest of Judge Halevi's opinion will be translated later and will be in the written transcript. President of Court, we shall stop here after the recess. You, sir, will still give us information about the Steger statement, and then cross-examination of the accused will commence. A 20-minute interval now.
What happened if you didn't?
Oh, don't ask.
Ich kann es Ihnen befreien. think the thing here.
By permission of court, in regard to Steger's affidavit, this includes, as far as we could see, during the recess, a number of declarations and statements, hearsay evidence, and this part of the affidavit will not be admissible. We shall study the affidavit carefully, but at this stage I do not intend to object and to obstruct the procedure, not because I agree to the contents of the affidavit, but for these reasons I consent to the submission of the document in evidence. Judge Halevi, we did hear and accept many hearsay evidence in this court. Mr. Hausner, yes, but this we must apply to paragraph 15 of the law. Otherwise, paragraph 10 of the law of evidence will invalidate this hearsay evidence. There is no cancellation of the rule of evidence, and paragraph 10 still applies. I shall ask to have a copy, and if the court permits, we shall be able to prepare copies. President of court, we also need 3 further copies. Judge Halevi, this is not clear. There are many documents which were submitted of the same kind where there was no special decision taken to differentiate and kind of mark off certain parts as hearsay and other parts to be admitted. There was never an objection voiced, because paragraph 15 was always referred to and relied upon, and there was no difference actually made between hearsay evidence and ordinary evidence. Do you mean to say now and to bring forward the argument in your summing up that a difference should be made between hearsay evidence and other evidence, or to leave this to the jurisdiction of the court as far as the probability of the evidence is considered? Mr. Hausner, I wish to argue that we are still to follow the law of evidence, and the rule of hearsay evidence still applies, unless the court was assisted by paragraph 15 of the law against Nazis. I wish to examine once again all documents where the rule of evidence paragraph 10 may apply, in order to avoid the cancellation and invalidation of many documents, such as we are interested in, for instance. Judge Halevi, this is only to clarify the situation which has been created now, because if the court is right, do we need a special decision, or can this be implied? Mr. Hausner, I understand the problem. Decision number 93, we permit the submission of the affidavit by Steger in evidence in this trial. The Attorney General does not object. This is marked as N99. I see that further copies are here. President of Court, these are further copies of the same affidavit by Steger.
Sind die notariellen Ausfertigungen.
These are the notarial copies. President of Court, do you have a copy for the prosecution?
Wird eine bekommen haben.
Dr. Servatis, I take it that he already has a copy.
Könnte ja sonst keine Kenntnis von dem Inhalt haben, wenn sie nicht da
He could not have known the contents. Attorney General, I have given my copy to the court, so I request that the court give me another copy. I have marked my copy for the convenience of the court. President of Court, I do not know how many copies we have here.
Eine beschworene Erklärung von Alois Steger, wohnhaft in Paris, Rue de la Banque 3.
This is an affidavit under oath by Alois Steger, living in Paris, Rue la Barre 3.
20. März 61 vor dem Notar Steinbach in Köln.
Was made on the 28th of March 61 in Cologne before the public notary Steinbach.
Hat zwei getrennte Erklärungen abgegeben.
He made two separate affidavits.
Vermittlung von Briefen nach Theresienstadt. Das ist ein Dokument, was in dem Kastner-Bericht am Schluss angeführt ist. Da ist abgedruckt ein Brief von Theresienstadt an eine jüdische Kommission im Ausland. Das ist aber nicht das, was Sie hier interessiert, sondern die nächste Urkunde.
The first affidavit concerns an exchange of correspondence to Theresian and the handing over of letters to Theresian. This was mentioned in Kastner's report. A copy of a letter from Theresian to a Jewish committee abroad is attached. This is not the interesting affidavit, but the following, the next affidavit, is the one I am interested in.
Als die deutschen Truppen am 19.03.44 Ungarn besetzten, befand ich mich in Budapest, wo ich eine Wohnung in der Mariengasse 5 hatte. Da mir sofort mein Kraftwagen beschlagnahmt wurde, bemühte ich mich, diesen frei zu bekommen. Ich wurde hierzu an den Obersturmbannführer Becher verwiesen, der für wirtschaftliche Dinge zuständig war. Sein Name war damals allgemein bekannt und erschien auf den Beschlagnahmeplakaten an den Fabriken. Er war der maßgebende Mann. Als ich nach vielen Bemühungen bei Becher vorgelassen wurde, verlangte dieser von mir zunächst einen Nachweis, dass ich Arier sei. Becher fragte dann, was ich als Slowake in Budapest zu tun habe. Auf meine Antwort, dass ich hier geschäftlich tätig sei, sagte er, gut, dann schaffen Sie mir Kaffee oder Koffein, das brauche ich für meine Flieger. Auf meine Entgegnung, dass es so etwas hier nicht gäbe, sondern nur in der Schweiz erhältlich sei, meinte er, ich würde Ihnen Ihren Waren freigeben, aber ich verlange dafür von Ihnen einen Gegendienst. Mein Einwand, dass ich in dieser Beziehung kaum etwas unternehmen könnte, wollte er nicht hören, er war unzugänglich. Dann befasst sich die Aussage mit dem Zustandekommen der Auswanderung der 318 Personen des Manfred-Weiß-Konzerns, wie er dort eingeschaltet war. Dann auf Seite 3 unten heißt es, dass die Transporte nach Bergen-Belsen nicht durchgingen und sagt, soweit ich unterrichtet bin, hat Salim Meyer in der Schweiz die Zahlung hinausgezögert. Dies sagten mir die jüdischen Kreise, die mir bekannt waren. Damals kam Dr. Kastner verzweifelt zu mir und sagte, Becher will nicht mehr helfen. Er sieht sich selbst als der Himmler gegenüber Blamierte an. Mit Ach und Krach kam es dann doch zur Durchführung des oben genannten Transport, für den ich die Waren geliefert hatte. Den anderen Text brauche ich nicht mehr zu verlesen. Ich nehme darauf Bezug.
Ja, oder?
Nun.
זוהי ראשית עדות בדבר כינונם
is first of all a testimony in regard to the emigration of the 318 people from the Manfred Weiss concern and what was the part played by him. It goes on to say, later I referred to my bankers, the Hungarian Commercial Bank at Budapest, the first part of Dr. Servatius' argument, when the German troops entered on the 1934 into Hungary, I was in Budapest at the time. I had a residence in Budapest on Maria Street 5. Since my car was confiscated immediately, I tried to have my car returned. I was sent to Obersturmbannführer Becher, who was the man in authority in regard to such matters. His name was known to everybody, and his name appeared on confiscation orders sent to factories and enterprises. He was the man to decide. When later, after many efforts, I was permitted to see Becher, he first wanted proof that I was Aryan. Later, he asked, what am I, a Slovakian, doing in Budapest? My answer was that I was here on business. If so, he said, get me some coffee or caffeine, I need it for my flyers. My answer was that I cannot get coffee or caffeine in Budapest, only in Switzerland. He said, I shall free your car, but I want a service in return. Then I contended that this will be very difficult for me to do. He would not listen. He could not be convinced. And then on page 3, at the end of page 3, the affidavit goes on to read in regard to the deportations, to transports which were not sent at the time. As far as I know, Salim Meyer delayed the payment in Switzerland. This I learned from the Jewish circles whom I knew quite well. Then Dr. Kastner came to me, quite hopeless and depressed, and said, Becher does not want to help anymore. He himself realizes that his good name was spoiled, and it was very difficult to carry out the mentioned transport, and in exchange I supplied the goods. Dr. Servatius goes on, I shall not read more out of this document, but I shall refer to the contents. Judge Halevi, maybe there is a typing mistake. At the end of page 8, it says $2,000. And on page 3 at the top it says $1,000 and it should have been $200.
Nein, es ist eine etwas unklare Angabe. Ich habe mit dem Zeugen Steger einmal gesprochen. Der Sinn ist folgendes, es ist umgekehrt gebracht worden hier. Becher hatte 2000 verlangt, Eichmann hatte gesagt 100 oder 200, ich weiß jetzt im Moment nicht, und darauf hatte dann Himmler erklärt, das ist Wahnsinn, es müssen mindestens 1000 sein. Das ist hier schlecht zum Ausdruck gekommen, das hat der Notar anscheinend nicht klar verstanden. Es ist sonst, es kommt dann, es ergibt sich aus dem Späteren in etwa, indem es heißt, dass Eichmann es für einen geringeren Betrag gemacht hat.
This detail is not clear here. I spoke to the witness Steiger, and this is described in the wrong order in the document. Becher demanded $1,000, Eichmann suggested $100 or $200, I cannot remember. Judge Halevi corrects the interpreter that Becher demanded $2,000. Is that what you said, Dr. Servatius? Dr. Servatius, yes. So, Becher demanded $2,000, Eichmann suggested $100 or $200, I cannot remember exactly, and Himmler said 5 million people were liquidated. You said that you used the expression 5 million enemies of the Reich.
Gegen Ende des Krieges erklärten Sie vor einigen Leuten, wie Sie auch heute Morgen sagten, dass Sie mit Freude in die Grube springen würden, im Bewusstsein, dass ihretwegen 5 Millionen umgekommen sind. Sie sagten, dass Sie damit mit 5 Millionen Reichsfeinde meinten.
When you were questioned at the police, in the same context, on page 308 of your statement, you said that you have voiced these things in the ears of your own men. Millions of enemies are dead. Millions of Germans are dead. And I believe that in this war also 5 million Jews found their death. Do you mean to say that both are correct? That you will jump into the pit gladly because you dragged with you 5 million Jews, enemies of the Reich?
Aber in ihrer Vernehmung, bei der Vernehmung in der Polizei, sagten Sie im selben Zusammenhang, dass Sie Ihren Leuten Folgendes gesagt hätten. Auf Seite 308 Ihrer Vernehmung. Millionen Deutscher sind im Krieg geblieben. Millionen Feinde sind ebenfalls geblieben und ich schätze, 5 Millionen Juden hat der Krieg auch gekostet. Es ist also beides richtig. Und Sie sagten, dass sie mit Freude in die Grube springen würden, da wissend, dass der Krieg 5 Millionen jüdischer Reichsfeinde gekostet hätte?
Nein, das habe ich nicht gesagt, 5 Millionen jüdischer Reichsfeinde. Unter Reichsfeinde verstand man zu jener Zeit die Feinde, die unmittelbar vor den Toren des letzten Bollwerkes der Reichshauptstadt standen. Und unter diesem Eindruck habe ich diese Erklärung abgegeben. Mit Juden hatte diese Erklärung nichts zu tun gehabt.
President of
No, I didn't say 5 million Jewish foes of the Reich. I didn't say 5 million Jews. When I spoke about the foes of the Reich, I meant the foe which was storming the gates of the capital of the Reich.
President of Court, will you please read the words as they were taken down from your own mouth?